The next speaker is Gintarė Pažereckaitė from European Data Protection Board. She's a legal officer there, and previously she was working with the Ministry of Justice in Lithuania. She also has a practical experience with legal compliance teams in the law firm, as well as one of the key mobile operators in the region. Today's topic of Gintarė is related to the changing regulations and changing legal requirements around AI in the European Union. So, Gintarė, the year is yours.
Thank you very much. Thank you very much for having me here. I'm very happy to be part of this very interesting afternoon with a lot of challenging and very topical discussions. So as Mindaugas said, I'm gonna talk about the challenge of regulating AI. And as I'm based in Brussels, I'm gonna, of course, give a Brussels perspective and also regulators' point of view. And I will try to do like inconcilable to give you the big picture, but also highlight a couple of practical considerations and what to expect in concrete terms from new laws on our way. Yeah, just like to start with overview of the legal framework, then talk a little bit about the relevance of GDPR, and just give a bit of a sneak peek of a new AI Act, which is currently being discussed. I guess the first message that I want to stress today is that more regulation is coming, especially when it comes to use of data, new technologies, of course, AI. So we are seeing a lot of legal initiatives currently being discussed in the EU, and that's really translating from hypothetical or theoretical discussions to concrete legislation. Already last year in April 2021, Commission proposed the draft regulation of so-called AI Act. It's currently going through the legislative process, and we are likely to see the results in a couple of years' time at the latest. And in general, there are a lot of different initiatives on the table, starting from Digital Markets Act. Only last week, Commission proposed the new Data Act, which also aims to boost data sharing. And we also expect the upcoming review of Product Liability Directive, which will be very impactful because it will revise the civil liability rules, also touching upon AI systems and liability of different actors in the value chain. So definitely there is a lot to look forward to. And the overall trend from being cautious about new regulation is now shifting to really going pretty hard, and EU is really aiming to set standards and kind of be the global standard setter when it comes also to regulating new technologies. For the time being, we are still with GDPR, and this is also another thing I want to reiterate, the relevance of GDPR. Of course, everyone is tired discussing about it, but it's still there and it's going to remain. And for the moment, it is still one of the most comprehensive laws when it comes to also regulating new technologies, and a lot of relevance also for approaching AI, just because it kind of has two different sides. So on the one hand, it provides for very comprehensive accountability obligations for companies, and then on the other hand, it also gives a very detailed list of rights to individuals, so providing also for very strong enforcement framework. It has been, from regulators' point of view, and especially from EU point of view, it has been considered a very successful piece of legislation. And in a way, if you look at what's happening now with new laws, many elements of GDPR are actually being replicated. Of course, a significant one maybe relates to the whole enforcement and sanctions framework. But there are also many other parts, like risk-based approach, for example, is also something that kind of comes from GDPR and is now being referred to when it comes to regulation of AI, for example. So just reiterate a couple of practical points of view from when it comes to GDPR, and it's relevant also to approaching AI compliance. Of course, GDPR is technology neutral, so that makes it kind of principles-based and also future-proof. So it's not aimed to address any specific technology, but in a way it does it indirectly. And yeah, you can see 3 blocks I have identified here, stemming from main principles to concrete accountability obligations. But I would like to mention just a couple of points I think are very important. Also thinking about how AI is being developed, how the data is used for this. So first of all, the requirement of lawfulness, and they need to have a proper legal basis. And I think it's important to highlight because very often development of AI also involves reuse of data. And in case it's personal data, then it's really important to make sure that the legal basis exists for any also subsequent uses in addition to the initial collection, which is often, for example, based on contract, but then it's important to verify if the subsequent uses can be based on any other legal basis under Article 6. And that's also something like a red flag that always has to be checked, and particularly relevant when we think about big data and high volumes of data being used for various purposes. And another element coming from accountability obligations is transparency. Then we deal with when we approach new technologies like AI, there is a lot of focus on transparency and ability to actually understand what's behind the very complex technological systems behind it. So transparency is like a buzzword when it comes to AI, and GDPR, of course, already provides for quite detailed obligations when it comes to transparency. And indeed, there is this requirement that information has to be comprehensible but also understandable for any person on the street, which is often a challenge. And there are a lot of discussions how this can be ensured. There are very interesting enforcement happening right now in relation to this. And I want to mention one particular case which is currently before EU General Court that relates to WhatsApp privacy policy. And it's a legal challenge against the decision of European Data Protection Board. So once the court reaches a decision, it will provide very interesting detailed interpretations on transparency obligations of the GDPR that will also be relevant for many other instances also in relation to AI. So just the GDPR is still there and most likely it will remain for a long time. But of course, we are also witnessing a change. And that is because maybe GDPR is not without flaws or that it's covering everything. Even if its reach is very broad, it still has limitations. So GDPR, of course, applies to processing of personal data, and it mainly focuses on obligations of controllers and processors. So then regarding the personal data element, there's more regulation now trying to tackle data which is not personal. I think I want to make a cautious point of that because there is a lot of enthusiasm about the use of data, non-personal data, anonymized data. But in practice, it's very hard to see the situation where you would be completely out of scope of GDPR. So whenever someone is promising great things and with anonymization or use of data which is non-personal, I would be very careful, and there is a really need to verify from legal point of view, technical point of view, if the standards really met. But again, as I said, GDPR applies to data controllers and processors. And there is a realization today that there are many players in the value chain who, for example, design or develop a system of software which is afterwards being used by the data controllers, while in fact the data controllers have very little impact on how they are made. So one of the purposes of the Future AI Act is actually to expand the regulatory power and also capture the players like manufacturers or developers who would already need to comply with certain obligations and ensure that any systems they are aiming for EU market have embedded certain safeguards in their design. So this is just a very brief overview of the AI Act, but I think the key message here is that it's really risk-based. That's in a way a concept coming from GDPR. So it has this layered approach and really aims to target the systems that, depending on their risks and the level on detail of requirements, will depend on how risky the systems are. And the risk is based, of course, on the impact on individuals, and not only the right to privacy, but also human dignity and freedom of expression and different elements. I think one of the core novelties is that this act might go as far as actually prohibiting certain AI systems because they are incompatible with EU values. Examples of these are, for example, mass biometric identification, which is done real time, like facial recognition in public spaces on a large scale, or social scoring on a large scale. So there are currently discussions around this, but there's the feeling that this is something that is not compatible with the EU fundamental rights, and there shouldn't be happening inside the EU, even if we see these trends in other parts of the world. And then, yeah, depending on the level of risk, the obligations will be there for different parties involved. I think important to highlight that it will be a minority of AI systems actually falling within the two highest risk categories, while majority would still be, considered limited risk, and those obligations would rather focus on transparency or some self-regulatory measures. So that's something important. Otherwise, the new act, as I said, is likely to come into force in a couple of years' time and provide for kind of new regulatory powers and sanctions, which is, again, a general trend in the EU to put concrete, directly applicable EU laws in action. And just for some kind of wrap up, I wanted to highlight these couple of points. So first of all, the legal landscape is changing, at least on EU level. But as EU law is becoming more comprehensive, more directly applicable, instruments like regulations are being agreed, it really has impact on operations of everyone inside the EU member states. And even it might seem to be far away, couple of years, it's going to come pretty fast, and it's really important to be prepared and take into account these considerations also in planning of different future activities, also for companies. It's also depends really on specific processing operations, specific systems. So I hear a lot, we speak about AI, but as a lawyer, I always have a trigger. So what's really behind this? So it's important to make sure, especially for lawyers who are advisors and work with compliance, to really understand what's behind different buzzwords and to determine what kind of obligations apply and what is the role of one or another player in this, and what is applicable on them. And just a final remark, of course, I represent European Data Protection Board, but I think it's pretty obvious that GDPR still remains the gold standard in terms of regulating technology, even if it's not the initial purpose of it. So yeah, GDPR compliance is a good starting point whenever you are dealing with AI or any other technologies. So this is very brief from my side. I'm very happy to answer any questions or continue the discussion. And I wish you also a very nice event all this afternoon. Thank you.
Thank you, Gintarė, for interesting presentation and for topic. I think, indeed, I have at least one very precious takeaway from your presentation, which is a buzzword of AI. Every technology and every software, well, developed or generated 5 years ago was sticked with this label of AI, artificial intelligence, because it was a buzzword. It was a popular word in a similar way that, let's say, all new companies established 15 years ago wanted to call themselves as a startup. But everyone understands when this buzz goes away, indeed, the lawyers, we as the lawyers, need to understand what's behind, what is really important about the methods, and AI not as a technology, but as a method, which is very important, well, first of all, to understand. So once again, Gintarė, thank you, and thank you for being with us.